thank you all for being here, making time to be with us. Really embodies that concept. Now, the topic of this 2015 TSI Symposium is right in the forefront of the news, our concerns, and it hits very close to home, and that is the issue of digital trade secret theft and cyber hacking. And we know, and I know from personal experience in private practice before I came to the law school, and this is more so now, it is actually very hard to find a significant U.S. business or organization that has not experienced hacking. And this is more prevalent today, and the problem of hacking being one of crime or ordinary theft, the problem of hacking being related to industrial or economic espionage, or the problem of hacking being an act of war or terrorism is very much something that we're coming to grips with as a profession and as a nation and as a world. And so the topic today is extremely important. I might say, unfortunately, this law school has recently been the victim, and some of our students, teachers, and staff have been the victim of a hacking attack that hit our cafeteria cash registers. And so we have this example, very much close to home about this rampant problem and how difficult it is not only to prevent cyber hacking, but then to respond to it and the burden it imposes on you. I will tell you that a few years ago, I was hacked, and some local criminals were taking advantage of my credit, and it was a real pain to have to deal with personally. But perhaps the biggest embarrassment and pain was that I was called by several friends and informed that I was listed in a big billboard as the Today's Man Customer of the Month. I mean, it couldn't have been Neiman Marcus or Saks Fifth Avenue. It had to be Today's Man. You get it, right? So these things have real burdens. For tonight, we're very grateful to the May Foundation for their continued support, and for all the people, our distinguished alumni, who have had so much to deal with the creation and the enduring success of the Trade Secret Institute, David Mitnick, and Alex Kaplan, and the Honorable Claire Kelly, who is not only an alum, a former and current professor, but my boss now as a member of the Board of Trustees of Brooklyn Law School. And we're really grateful that Professor Beecham, who had really, I can't say big slingbacks, but had major successes to follow, has done so ably well and performed so well. And by the way, his book, Invented by Law, is a great read and not unrelated to this field, but dealing with the litigation and the history of patents in the United States. And it's a wonderful book, and it's a great read, and I recommend it to all of you. We're also really grateful for the support and work of the TSI Fellows, who once again are among the very best students in this law school. And this year it's Jacqueline Genovese, Robin Warren, and Brittany Lashinsky. And so thank you very much, all of you, Brittany, Jacqueline, and Robin, for your work in supporting the Trade Secret Institute. With that, we've got a wonderful panel. I don't want to delay any further, and I hope that you all enjoy it. I'm going to get a full report on it. I'm not able to stick around. I'm going to run out and raise some money for the law school, so I hope that you wish me well and forgive me for my absence. But I hope you have a wonderful evening, and I know, given the panelists that we have here, that it's going to be very, very worthwhile. Thanks very much.
Hi, folks. I'm Jonathan Askin, and I'm here speaking on behalf of CUBE. But before Nick leaves, I want to say one thing about, I think today's man hack was probably better than the hack that was perpetrated against me. I think I was probably the Eli Tahari Woman of the Month. So.
I think Goodwill Industries would hack your.
And mine was perpetrated by an ex-wife, not a cyber hacker. In any event, I just want to say, I think, two words. One is hacking gives hackers a bad name. Through whatever you discuss in the world of cyber hacking, there are still white hat hackers out there. Here at Brooklyn Law School, through Blip and through CUBE, we started something that is now probably the largest global movement of tech-oriented lawyers in the world. That's legal hackers, all right? And this is not hacking for nefarious purpose. This is trying to deploy technology to improve the law and legal process. In fact, I'll be going up this weekend to MIT for a future commerce legal hackathon with lawyers, policymakers, and the mad scientists, technologists at MIT working with us. So just bear that in mind as you think about the ramifications of hacking. There are white hat hackers out there doing very noble activities. The only other thing I want to say is I am so proud that Brooklyn Law School has become one of the preeminent homes for trade secret study, the secret IP. I think years ago when we were first thinking about what we were going to do in the IP world, I think people weren't fully aware of how potentially relevant becoming the home for trade secrets studies was going to be. And I think it certainly will become more and more profound as the years go by. So with that, I'm going to hand it over to Robin. Is it Robin, you taking over? Who's taking over? Jackie's taking over, great.
Much taller than me. Thank you, Dean Allard and Professor Askin, and thank you everyone for joining us tonight. Before we begin, I would just like to remind everyone who is here for the CLE event, before the reception starts, if you could fill out the forms and bring them to the back so we can all get you your CLE credit. My name is Jacqueline Genovese, and I am one of this year's Trade Secrets Fellows. On behalf of myself and the other two fellows who will be moderating tonight's panels, we would like to welcome you to our symposium, Protecting Trade Secrets in a World of Cybercrime. The mission of the Trade Secrets Institute and the goal of the symposium is to explore trade secret protection. Our institute, through the work of the fellows, provides comprehensive reviews of recent trade secrets cases. Some of our most recent work includes analysis of the Jawbone Fitbit dispute in San Francisco, the Elena Koff case, which took place right here in New York, and the recent guilty plea of a businessman who stole trade secrets valued between $65 and $150 million. With cybercrime on the rise, both private companies and the government are facing new challenges in protecting their trade secrets. We hope these panels tonight will give you some insight into how experts from the government, academia, and private practice defend themselves against cybercrime attacks and prosecute those who are responsible. With that, I'd like to turn it to Robin for the first panel.
I'm Robin, and it is my privilege to introduce our panelists this evening who are going to talk about prosecuting and investigating trade secret theft at the state and federal level. We have Mr. Glen Graham, who is a Deputy Attorney General with the New Jersey Office of the Attorney General Division of Law and is a member of the Consumer Fraud Protection Section and the Internet Privacy Working Group. We then have Mr. Saran Turner, who is an Assistant U.S. Attorney in the Southern District of New York, where he serves as the office's cybercrime coordinator. And then we have Mr. Austin Burglas, who is the Senior Managing Director and Head of the U.S. Cyber Investigations and Incident Response Practice at K2 Intelligence. So, gentlemen, thank you for being here tonight. Before we get started with questions, just wanted to go down the line and perhaps each of you could talk a little about your practice and experience and how you got into the cybercrime space. So with that, Glenn, why don't you start?
Can everyone hear me? So my name's Glen Graham. As Robin said, I'm a Deputy Attorney General over in New Jersey, and we are part of the Privacy and Cybersecurity Working Group. We're a little different as far as we're in the civil enforcement practice group, so we don't have criminal authority. There are people in our state that do have criminal authority, but we are more akin to kind of Federal Trade Commission investigation, as we're a consumer protection agency. But I just wanted to, as far as I got into the cybersecurity, I wanted to echo Professor Askin's comments about the white hat hacker, as that's pretty much how our group got started. A number of years ago, we had a great researcher team up with us and kind of give us some leads into investigations, and our team would not be here without his help. So I definitely echo his comments.
Thank you. Sarah?
So I'm an assistant U.S. attorney in the Southern District across the river. We have a unit in our office called the Complex Frauds and Cybercrime Unit. We're about 8 or so AUSAs spend a good chunk of their time prosecuting cybercrime cases, and it's a range of investigations and prosecutions we do in that area. We've done things like the prosecution of the anonymous LulzSec hackers, Jeremy Hammond and others who went on a hacking spree several years ago, and sort of hacktivist attacks. We've done hacks of major financial institutions, like the hack of JP Morgan Chase that was just recently charged. We've done Silk Road case, dark market cases where you have large black markets operating to a large degree with impunity on the dark web. Digital currency cases involving money laundering through the use of digital currency. So we really do the whole spectrum of cases. In terms of how I got in the area, I started out in the office and knew I wanted to do some sort of white-collar crime, but this seemed to me the most interesting white-collar work that's being done in the office. It's very fast-moving, it's a rapidly changing, evolving area. It's very international. A lot of the bad guys are abroad, a lot of the infrastructure is abroad, so you're working constantly with foreign law enforcement partners. And the defendants are sort of smarter and more unusual than in a lot of other contexts. So I found it a really interesting, rewarding line of criminal work.
Great. Thank you, Saren. Austin?
So I'm the only attorney, probably not in this room, so Saren's offered me $20 for my CLE credit. Is any higher or better than that? But I've been at K2 for about 6 months, and the previous 22 years I was with the U.S. government, and the last 16 of those with the FBI, and all in the New York office. And the last 10 of that leading the cyber program in the New York office and working on the investigative side on the majority of the cases that Saren talked about. I got into cyber early on in just before 9/11 when the FBI's kind of precursor to what cyber is today was cyber-enabled crime, specifically child exploitation. So I worked child exploitation cases for about 7 years. And then in the early 2000s to mid 2000s, cyber changed, and the government started taking a hard look at really what it is today, which is state-sponsored attacks and organized criminal groups for financial gain, and that took me up to the time I left in May. And now at K2, we are a services consulting organization. Corporate investigations, and I run a team of folks that do everything from assessment services with all sectors. We're talking pen testing and vulnerability assessments and architectural reviews, making sure that companies are secure. And we also do incident response when and if there's a problem, and then we do the remediation phase as well. So everything that has to do with a cyber-enabled crime.
Great. Thanks, Austin. And you actually just touched on my first question, which is I was wondering if you could speak to the two different types of trade secret theft that really occur. There's the state-sponsored entity, which is under kind of the Economic Espionage Act, and then also really more trade secret theft for pecuniary gain. And so wondering if you could speak to the differences in the types of investigations that you would do for either one of those, and if there are any challenges that you face with each.
Sure. So, as Robin said, the kind of, if you had to bucket it in two groups, the state-sponsored side, I think in order of the most prevalent out there right now, you can say, is China, Russia, Iran, in that order. And from a technical standpoint, I think it's Russia, China, Iran. They're looking to gain, economic, political, or social advantage over the United States by stealing anything and everything in the IP space. It's just like the other side, which would be the corporate espionage or the insider threat. These nation states, as well as the criminal groups who are doing the theft, use really what's known as the path of least resistance. You're not seeing incredibly technical hacks to compromise some of the largest breaches you've heard about in the news, and that's because the majority of the breaches are due to human error. 80% of the successful attacks are because someone's susceptible to a spear phishing email or some other weak link in the chain. Too much privileged access inside a network. There are armies of individuals over in China who wake up every morning and come to work, and they log on to their computer screens and they look for vulnerabilities. They identify vulnerabilities, and the next wave of soldiers come on and they look to exploit those vulnerabilities, and they harvest as much information. So the state-sponsored side, specifically from China, crosses all sectors. When you look at the criminal side or the competitive advantage, the corporate espionage, you have oftentimes insider threats. Sometimes those insiders are witting, sometimes they're unwitting. But if you're looking at disgruntled employees who potentially are angry after they're fired and their access is not cut off, and they go to a competitor, or they want to steal information and send it to a competitor, we see an awful lot of those cases, and I see those more typically in the private sector. We're not so heavy into the state-sponsored side, although it turns out a lot of the companies that think they have an insider threat or that they're attacked from a criminal-minded folk is really a problem inside from China. Difficulties with these investigations are probably the same for both, and that is most companies don't have enough robust logging around the information that they want to protect. Oftentimes that information, trade secrets, crown jewels, whatever you want to call them, oftentimes that information is sitting right exposed to the internet. And pretty much everybody at this table can probably tell you that any information that is exposed to the internet is going to be stolen one time or another. It's the most vulnerable avenue inside an organization. So when you have trade secrets or something that if stolen or damaged would cause irreparable harm to the organization, and you leave it exposed to the internet, that creates a problem. A lot of companies just don't log and put enough time and money surrounding protecting that information. So when a company or the government comes in to do that investigation, and a company says, hey, we believe that our competitor has stolen these trade secrets, it's causing us a lot of damage and harm to our reputation, that investigation is difficult to nail down, to figure out how it was taken, where it was taken, and how it left the organization. It's oftentimes finding a needle in a haystack. It might be, they might know that information is out in the open web or in the dark web or at a competitor, but actually tracing it and figuring out how it was stolen and who did it is common in both of those cases.
Thanks, Austin. Saren, in your experience as a federal prosecutor, would you agree with Austin's assessment, and how do you come at it from the prosecution angle of under what's your enforcement authority and what other types of investigations you do?
Well, let me start with enforcement authority. So for us, there are a few statutes we can draw on. First, there's the Economic Espionage Act, and it addresses both types of cases that you just described. There's one provision that specifically applies to economic espionage that's done for the benefit of a foreign entity, and then there are others where it's misappropriation of trade secrets for the benefit of the perpetrator or third party. So there's those two specific statutes, and then beyond that, we have that computer hacking statute, 18 U.S.C. 1030, which because a lot of these attacks are done through digital means these days, you can have a basis just to bring a hacking charge, regardless of whether it was trade secrets that were specifically hacked. Just the intrusion itself could be a crime. But Austin's exactly right. I mean, in terms of the nature of the threat, it really does break down into two general categories. You have the insider threat, and then you have the foreign-based threat, and the cases really do look a lot different. I mean, the insider threats, oftentimes there's going to be a lot more of a clear link, a clear trail that the company's going to know about. I mean, you have a disgruntled employee that left with certain information, and suddenly that information shows up in the hands of a competitor and somehow, so there's going to be much more of a head start in terms of the investigation. For the Chinese-based or foreign-based economic espionage that's going on, I mean, a lot of the hacks may go unnoticed for months or even years because the intrusion into the network is just not noticed by the company. And by the time it is noticed, you may not have much of an evidentiary trail to follow. I mean, what we have to do is you start with the network of the entity that's been hacked, and you have to see where that data was exfiltrated to. Like Austin said, you may not even be able to see the exfiltration because the logging was not done in an effective way by the company. And even if you find where it went to, it could be some server that has been wiped clean, or it could be that the hacker was using anonymizing technologies like proxies or VPNs or even Tor. So there are lots of problems we face in any hacking case, sophisticated hacking case these days. And then even if you are able to do a full investigation and find the perpetrators, there's the issue of whether you're going to be able to put cuffs on them at the end of the day. If they are based in China, you're not going to be able to extradite them. So there are certain, you can still use prosecution as a tool in some ways. I mean, you have the Pittsburgh indictment of 5 members of the Chinese army for hacking, and that certainly was useful to educate the public about what China is doing and to put political pressure on China and to restrict the travel of these individuals who, I mean, they're educated individuals. They may want to travel to the West someday. If they try to, leave China and go to a country where we have Interpol relationship there, they're going to be picked up on an arrest warrant. So there are certain consequences, but the use of the criminal justice system is not going to be as effective against those foreign targets, given those limitations we face in these cases.
And Glenn, at the state level, what sort of challenges do you face with your enforcement authority, and how do you go about an investigation into trade secret theft?
Sure. So I guess we come at it a little differently. There's really two main areas, general broad areas of our investigations. We like to call them the proactive investigations and the reactive. And a data breach or a data security leak I could consider a reactive. In other words, we come in after the fact. And we're concerned with consumer information, which would be the company's trade secret in this case. So we would investigate the company actually for not having adequate security measures in place. And that could be from failure to patch known vulnerabilities, failure to update their networks, failure to adequately monitor and scan their networks. And that would come in play whether it's a state-sponsored entity hacking or insider hacking. We also come up against the case pretty often where it's negligence, the stolen or lost laptop. Person goes outside and loses a laptop with customer information, trade secret information on the laptop, and when that information should not be on the laptop and the corporate policy says to not bring it out. So that's really where we encounter trade secret in our investigations. But again, it's up to the company themselves for a failure to have adequate security measures to safeguard their customers' information.
Thank you. Saren, you touched on some of the challenges that you face when you're prosecuting these trade secret theft cases. I was wondering if you could speak to the recent Alenikov decision and what challenges came out of that, or what really was was seen as a weakness of the Economic Espionage Act there, and then the recent amendment that came out of that.
Right, so Lenikov, I think that was back in 2011 or so, and that was a case where it was an insider case, and it was a former Goldman Sachs programmer who was convicted of violating the criminal trade secrets law for stealing high-frequency trading code from Goldman Sachs. So this is code that computer algorithms that Goldman Sachs would use to monitor stock trades in the market and try to exploit tiny price discrepancies. I don't know how it all works, but basically it's their system for executing these high-frequency trades. And in that case, which my office prosecuted, the defendant was convicted in district court, but then the circuit court found that basically the trade secrets law was a little bit anachronistic and written in a way that was designed for physical products in commerce. So what the court held was this is not tangible property. It's not the language of the statute was not a product that was produced for or placed in interstate or foreign commerce. It's not something that's sold in interstate commerce in any tangible way. And so the court found that it didn't meet the terms of the statute and reversed the conviction. Interestingly, we had a very similar case around the same time, United States v. Agrawal, very similar because the individual there was another insider that stole high-frequency trading code, this time of SocGen, and the Second Circuit upheld that conviction. And it said there the guy printed out the code rather than uploading it to a thumb drive, and so that was tangible. And found that it actually related to products in interstate commerce with the securities being traded being the product rather than the code. But anyway, in response to the Second Circuit's Lenikov decision, Congress actually amended the statute to change the language, and now it makes clear that it applies to both products and services, and that the product need not be produced or placed in interstate commerce, but instead just sort of intended for use somehow in interstate commerce. So it's an example where Congress had to broaden the statutory language to fit these new contexts that these crimes are occurring in.
And do you think because of this amendment that there will be more cases brought when there is trade secret theft? Because they have been uncommon. Is that right?
Yeah, I'm not sure that's the reason they've been uncommon. But I think it'll certainly solve an obstacle that the courts threw up. I think the reason these prosecutions can be uncommon, I mean, a lot of the problem can lie in companies not reporting them in the first place. If a company's been hacked, I mean, this is a problem we encounter generally in the computer hacking context. If a company thinks they've been hacked by a foreign actor or any actor and valuable information has been stolen, they may not want to report that because they may fear, for example, that the information might get out through the criminal charging process. That they may be disclosed as a hacking victim, that their stock price could be harmed, that it could be embarrassing. I think there can be a lot of hesitation on the part of companies. And then, there's also, I think, some cases where the government may not feel like it's a good case for the government to investigate because the information may not be sufficiently valuable, or it may be a case where private litigation could resolve the situation. But I think the main issue can be both the failure to report and just the investigative obstacles that we talked about before, especially when you're dealing with actors halfway across the world. So.
And Austin, do you find the same hesitancy when you're dealing with companies that come to you after there has been a breach and you're beginning your investigation?
So it's interesting. I had a view from my years in the FBI as to why companies were so hesitant to report. I thought it was that they were scared of the government. and for some reasons that Saren brought up. And now, dealing on the other side and working with companies usually under privilege with outside counsel, a lot of those reasons are true. They feel that it would bring on a lot of regulatory scrutiny. They are a lot of them are very nervous that they don't have a good understanding of how badly they've been hacked, and that if law enforcement were to come in and investigate, they would find a lot more. So most organizations want to do the route of retaining outside counsel, having a security vendor come in and assess the situation and help them clean. Clearly, I mean, if they identify that there's PII or there's mandatory breach notification that needs to be made, they do it. On the flip side, still I find a lot of organizations are notified by the government that there is a breach, and then that's obviously a harder decision when you have FBI or other agencies knocking on the door saying that we've seen your documents floating out on the in the interwebs, and we want you guys to allow us to monitor. It's harder for the organizations to say no, but they do it, and it's for the same reasons. But if you have individuals who understand what the government intends, the government, when they notify an organization that they have a problem, their intent is totally different than what like a K2 organization would want. The government has an investigative view, an intelligence collecting view. They want to monitor the activity of the actor. There's a lot of cases that the government does that don't bring in the U.S. attorney for prosecution purposes. It's intelligence gathering. We know that the Chinese is active on a network. Government wants to monitor that activity to gain understanding of their tools, techniques, and procedures, what they're looking for. Now, if the actor is off the network and there's a historical investigation to be done and there's legal process to be had, then we work with the U.S. Attorney's Office. So that's one way, and then the private security firms like K2 are there for containing, eradicating, assisting in remediation, as well as helping to investigate and oftentimes coordinate with the government investigation.
Glenn, when you're deciding to prosecute a company for having negligent security policies in place, this is obviously the other side of what these gentlemen are talking about. And I'm curious, what obstacles do you run into when you're investigating these companies, and what kind of pushback do they have?
So it's interesting actually, because we mentioned breach notification statutes. I think there's 46 or 47 breach notification statutes throughout the country, and their standards are actually very different. There's no uniform breach notification throughout the country. So what may require notification in California may not require notification in Florida. So that is an issue as to when to make a notification and to who, because it depends on where the residency of the actual consumer is. So if the company is based in California and they have a Florida client or customer, they may have to notify that person in Florida, but they didn't notify Texas, but then it gets out and they have issues, as Austin was talking about. But as far as pushback, it really is a case-by-case basis. A lot of companies now know that we are in contact with all the other states. We collaborate among the other state privacy contacts and the federal authorities. And so they'll give us a heads up a lot of times and say, we had a cyber incident. We can't really tell you much because it's either still investigating or law enforcement is investigating, and they say you can't tell you much, but we do want to give you a heads up to try to keep a good relationship with the states. So we do see that actually pretty often now, especially in the last year. As far as prosecuting, again, some other challenges are companies are concerned about their trade secrets and them getting out. So what we have, and I'm speaking of New Jersey only, is we try to assure them there's a bunch of reasons why they're privileged. The trade secrets are not going to get out in response to an inquiry. One, we have an investigatory privilege, so that as long as it's an investigation, no information is going to get out. Then usually we get the attorney response is, well, what about if the investigation ends? What's your data retention program and Open Public Records Act? So we do have a 7-year data retention program in New Jersey. It's different in different states, so we can't destroy them until we have to retain them for 7 years. However, one of the benefits we have, and this is just specifically for us, in investigating data breaches is that trade secrets are specifically exempt from our Open Public Records Act. So we could hold on to trade secrets forever and not disclose them. And that's really a great tool that we have that not every state has. So when you're in your future role as an attorney and who your client is, you have to be aware of whether or not those trade secrets can be protected under state law, because it does vary state to state.
Great. Thanks, Glenn. And do you find at the federal level, Saren, that you're able to also protect the trade secrets of companies?
Yeah, so I mean, I mentioned some of the worries that companies have in this area, but you know, I think a lot of those worries are failure to understand how the criminal process works and sort of lack of education among the companies about some of the protections that are available. So for trade secrets in particular, I mean, the Economic Espionage Act specifically speaks to this and has a special provision for protective orders during the investigation and any criminal proceedings. You don't have to prove, for example, that whatever you're talking about is a trade secret for a protective order to be placed into effect. It just has to be alleged that there are trade secrets at issue. And in that sort of instance, you know, you can have a protective order that, you know, in the discovery phase and what you're giving the defense counsel, the protective order can limit their access so that the information is stored in a secure place. It can limit who they can disclose the information to. It can limit, you know, how they can transmit the information, so they can't email their associates about it or something like that. They would have to return materials after the closure of the case. In any criminal trial, there's lots of measures that a court can impose so that, you know, witnesses aren't talking about details of trade secrets, that the testimony can be kept to a general level. You can have a obligation on the part of the parties or witnesses to notify the court if any testimony is going to touch on trade secrets, and so that appropriate precautions can be taken. In an extreme case, you could even have a sealed courtroom. So, you know, for us, I mean, it's interesting hearing Glenn's perspective. For us, the government does not want to be in the position of re-victimizing victims. I mean, if a company has reported some theft of trade secrets or other hacking into their network, we are there to find the perpetrator and punish them and make the victim whole to the extent possible. So we are going to want to protect their interests and want to encourage other companies to do the same. So we're going to take measures that like protective orders and anything else we can do. Certainly during the investigation, you know, we're not going to release the fact that this hack has occurred or this theft has occurred. So we're try to do what we can do to protect the victim's interests.
And once a company is hacked and they have experienced trade secret theft and they are pursuing federal prosecutors to help bring a case, what are the steps that a company needs to do to actually enlist a federal prosecutor's help?
Well, I mean, fundamentally, they need to report the incident to either a law enforcement agency like the FBI or directly to the U.S. Attorney's Office. But, you know, they immediately need to do things like, you know, treating their network like a crime scene and preserving the evidence as much as possible. So things like Austin was talking about logging, making sure if the intruder is still active in their system, you want to maximize the logging to maximize the record keeping of what he's doing. Imaging any affected servers. I mean, sometimes I think companies are tempted to just sort of wipe the servers clean and get rid of the whatever infection is at issue, but you want to, you know, instead image and keep accurate records of the forensic evidence, and you want to document everything that you're doing in connection with that, so that, you know, when witnesses need to be called later down the road at a potential trial, they can accurately, you know, reconstruct what was done to identify the intrusion, figure out what data was exfiltrated. So they can certainly do things like that to help assist the investigation and get it off to a good head start.
And everything Saren just said would aid the company on our end as taking reasonable steps, because really it would be a case-by-case basis whether we investigate or prosecute, I should say. And doing all those steps is what you want to do as a company.
And as far as when you're dealing with the company, what do you find are the defenses most commonly invoked?
Well, I think we touched on it. It's the sophistication of the attack. If it's you know, a highly sophisticated state actor that this is not a known vulnerability, it's never happened before. It's novel. It's unique. They had adequate monitoring in place. You know, they did everything they could do. If there's standards, say it was a payment card system that was hacked and they were compliant with payment card industry data security standards, you know, we find those defenses a lot that basically we were doing everything we can do. And if it's basically I don't want to say it's a reasonableness negligence balancing test, but it is, you know, a case by case analysis in that matter.
And Saren, what defenses are commonly invoked in your territory?
Well, so it would be sort of the opposite point of view for trade secrets prosecution. For a defendant trying to defend against a charge like that, I mean, they would, part of the trade secret, the elements of a trade secret prosecution, you have to show that the information really was a secret, that the entity, the company took reasonable measures to keep it secret. That's an element of the crime that you'd have to show. So they would want to point to some of the things that Glen was just talking about, that the company didn't have effective network security. They didn't do things like encrypt their sensitive data, encrypt the trade secret that was stolen. They didn't have things like you know, regular password changes and restrictions on who could access the network. So it's sort of you know, where an intersection between trade secret law and, you know, cybersecurity concerns. You know, if the company had very lax cybersecurity, then there's an argument to be made that it's not really a trade secret because the company didn't take reasonable measures to keep the information secret.
Austin, in your experience, touching on actually what Saren just said, do you find that there are cases where you have to explain to the company, look, we're investigating this trade secret theft, but ultimately your security policies weren't effective, and so it's actually not considered trade secret material?
I have not engaged in those conversations. I mean, you know, in the investigative, from the FBI side, the government side for investigation, you know, we have early and frequent conversations with Saren's office, U.S. Attorney's Office, about, you know, what can be charged. We do our investigation. You know, if it's an insider theft case, you know, we want to find out, you know, gather the evidence about where it was taken. You know, like Saren said, was it encrypted? How was it protected? What steps did the company take to protect it? And then trace the steps that the attacker did to remove it and steal it. And then on the private side, you know, that really doesn't come up. Oftentimes, in my 6 months, we've had, I think, probably two cases where what the company said was trade secrets. I'm not sure if it was ever categorized as trade secrets, but they believed it was their secret sauce was stolen, and then my organization did the investigation to help them figure out where that data went and who stole it. You know, in both of those cases, we recommended that they refer the case to law enforcement. They decided not to in both of those cases. In one of them, we were able to find who did it. In the second, we were not, because the content management system was archaic. They had absolutely no logging anywhere in their environment. They had everybody in the organization, including the employees who were in Singapore, the ability to have access to everything inside that content management system. So everybody had access to everything. It was impossible. So we never found out who did that one. So, you know, from the investigative side, the question of whether or not something is a trade secret doesn't necessarily factor in. We're doing the investigation. We do it the same regardless of whether or not, you know, Saren's office believes that they can charge that as a theft.
Thank you. Beyond criminal prosecution, what other tools are available to the government to deter theft of trade secrets? Saren, do you want to start?
You said beyond trade secret prosecution?
Mm-hmm.
Like I mentioned before, there's the hacking statute, which prohibits any unauthorized access of a system for various purposes, like for commercial gain. One area where that is proven difficult to prove up a case in the trade secret context is insider cases. And that's because a lot of times insiders have authorization to access the system, and it's a question of whether they've exceeded their authorized access, and which is another part of the hacking statute. The courts have construed that language narrowly, which I think has hampered the government's ability to bring hacking cases in that context. In fact, Olenikov was charged, among other things, with hacking violation, but that charge was dismissed precisely for that reason. But beyond criminal prosecution, I think another tool that people should be aware of is the sanctions regime that the administration recently announced. I think it was 6 months ago or so. Basically, President Obama authorized a system of sanctions that parallels the economic sanctions that the government has imposed for years in the terrorism context. And the idea here is that the Treasury Department can block property, block access to the American financial system by not only foreign hackers who are involved in economic espionage, but also the companies that benefit from their activities. So a company that knowingly receives or uses hacked trade secrets for competitive advantage can be sanctioned in this way under this new regime. And for that sort of sanction to apply, you don't have to meet this kind of evidentiary burden that we have to meet in the criminal context. It's an administrative decision, and so that I think is important, a much more flexible tool, and has the ability to allow the government to reach halfway across the world and actually, impose some penalties with some teeth on them, on these actors and the people benefiting from their crimes.
Beyond what you just mentioned about exceeding, one of the issues with the CFAA, exceeding authorized access, and then the other challenges we discussed with the Economic Espionage Act, are there other weaknesses that that we need to be aware of in the federal regime when it comes to prosecuting these types of cases that you've noticed crop up, or are those the main ones?
I wouldn't necessarily say weaknesses of the federal regime. I think it's more that these crimes and the investigations are international, and so you have to work with foreign authorities. And the government has gotten much better at doing this. I mean, this is a regular part of our work, and we have effectively made it a priority at SDNY to develop great personal relationships with foreign counterparts that work in this area, so we can get quick responses from them. But it's by no means seamless, and it really varies from country to country. And it's an area where there really needs to be more international work in terms of harmonizing not only the substantive laws, but sort of the procedural laws that are in place, so that when we need some investigative step taken in France or the Netherlands or Latvia that we would ordinarily accomplish here, we can have an effective mechanism to get that done. And if we trace the activity to a server in Latvia, and we need a search of that server done, there needs to be reliable steps we can take to get that information and get it in a timely way. I think that's one of the biggest challenges in the area.
And Glenn, when you're coming at it at the state level, I would imagine, you know, just today's world, there are no real borders anymore. Everything's going to cross, especially if there's a breach in a company and the consumer information is going to maybe in Jersey, maybe in New York, maybe Connecticut. Just wondering if you could speak to the collaboration efforts that you undergo when it comes to prosecuting these types of cases.
Sure, and we do collaborate pretty extensively, and we know there's counterparts similar to me and my colleagues. If there's not a team, there's at least a contact designated at the state level in each state in their consumer protection division that handles privacy-related work. And you mentioned actually a couple of cases, a couple of states that we collaborate with a lot: New York, Connecticut. I know we're on a first-name basis. We contact them all the time. Even if something comes up in the news, we'll exchange emails to say, "Are you looking into this? Is this something you want to do? Should we call them up? Should we send a letter? Should we send a subpoena?" So that happens pretty frequently. For all the large-scale breaches that you see, if we're investigating a company, a major newsworthy one, I almost guarantee you there's more than one state involved, and sometimes it's upwards of 20, 25, 30 states involved. So they're pooling their resources and investigating together collaboratively. So that is something we do all the time.
And what are the weaknesses that you see at the state level for trade secret theft prosecution?
So probably the biggest resource issue would be lack of not institutional knowledge, but lack of the resources on the institutional level. We don't usually have the capability to engage a forensic in-house person, so we'd have to go outside. Hire outside firms such as K2 to go in and do the forensic analysis of the breach and let us know how it happened. I don't think there's many states that have that in-house capability, so that's probably one of the major resources. Major issues. Jurisdiction does come up as well. If it's they do fight us if the subpoena comes from New Jersey, but the company's located out of state. They're saying we didn't have anything to do with it. That doesn't usually work out for them too well, but that is an issue that comes up at the initial stages.
And when you are collaborating with other attorney general offices around the country, how do you decide who is essentially going to take the lead on handling the case?
That's a good question. It depends. I think there's some states that are more active in the area and have more staff, more attorneys than others. So usually the way the structure breaks down, there may be a lead or liaison state that interacts with outside counsel, but there's generally another tier of states, just executive committees, usually what they call it, that works on the case and does a lot of the legwork. And that's generally, there's the same 10, 15 states that are usually on those.
And maybe Saren can touch on this. I guess, would you maybe be able to elaborate on the relationship between a state level investigation and at the federal level, and kind of how that would work?
Well, honestly, occasionally we run into investigations that are being pursued or involve some of the same targets as the state authorities, local DA's office is looking at, but I think it's a lot more common that we run into other federal investigations. So, SDY might be looking at some hacking victim, and then it turns out that, you follow it to an email account that you think is being used by the actor, and it turns out that email account is being also looked at by Los Angeles because it's tied to a hacking victim they have out there. And when that happens, you just sort of deconflict. You figure out who has the most equity, the most skin in the game, and hopefully reach some sort of amicable resolution. Sometimes it's not so amicable, and you have to sort of go up the chain of the Department of Justice and get a ruling. But I think those are the more typical coordination issues we face, as opposed to the federal-state divide.
And I know we already talked about a company's hesitation with why they would want to reach out to prosecute trade secret theft, but I wonder, because this is so present in our lives right now. Like Dean Allard mentioned that the school was dealing with this the last couple weeks. Have you noticed an uptick in companies either reaching out to you to enlist help in prosecution or perhaps to Austin for investigations? And then are you seeing an uptick in kind of a caseload? So just open it to the panel.
I have seen an increase over the past probably, I'd say 5 or 6 years. I think there is a, we always used to say that we want companies to report, and they're not reporting. I think a point that Saren made earlier, which is a lot of companies who are hacked don't even know it, and I've seen organizations have the presence of a state-sponsored actor in there for 6 years before someone told them that they had a problem, and that actor was actively exfiltrating data. So I think sometimes they just don't even know, but I have seen an increase in reporting, and I think that's based on a number of things, and that is over the past few years. And it started with a company called Mandiant. They reported they released a report called APT1, which basically outed a Chinese hacking group that did significant compromise, and they identified them by name and took, showed pictures of their building. And then shortly after that, the New York Times reported that they self-reported that they had a hack of the Chinese, and then it kind of it led companies to realize that maybe the right thing to do is report it. It seems like everybody's got the same problem, and that's kind of turned into now the administration talking about cyber sharing initiatives. So I think we're going in the right direction. It's not when we get past 47 different state breach laws and have one mandatory breach law in the U.S. I think that'll help. Codifying the president's initiatives for cybersecurity sharing, which is bouncing around houses and Congress and everything, which hasn't been codified after a few years. But I think we're going in the right direction. But yes, I have seen an uptick in the amount of companies coming forward.
Yeah, I think I would agree. I mean, I think the message has gotten out that companies should report, and in some cases are going to have to report. I think what companies really need is just clear rules of the road. It is confusing to deal with 47 breach notification laws and what the liability is going to be. So hopefully as the law develops in this area and the rules become clearer, companies are going to be able to make calculation about whether they have to report, they need to report more quickly and more clearly, and are going to be able to report more routinely as a result.
And have you noticed an uptick in your cases?
Yeah, I think that's accurate.
Mm-hmm.
And I think for our state law, our breach notification law is actually not as broad as some other states. And we've seen some instances where you mentioned dealing with the 47 other notifications where they probably didn't have to notify us under our law, but maybe had to notify under California or Massachusetts, and they just provide us notice anyway. So we've seen some of that recently.
Well, that's it for my questions. I'd like to open it up to the audience. Anyone wants to ask a question, feel free. I think there might be a microphone circulating that we're getting right now. I think we have a question over here.
Actually, can anybody hear me right now? Or do I need a microphone?
Nice
No,
voice.
we actually need it for the recording. Yeah, sorry.
Sure. This message is for, this is for Austin and the whole panel. Would you advise a client to possibly go after the hackers or at least seize their property? Like how Microsoft went after about 18 Jane Does, and they got a blessing by, I think it was the magistrate judge of Washington District Court. They basically went criminal trespass, trademark, and also, I think, Section 18 U.S., 18 U.S. Section 1030. Would you advise them to do that?
So I think I understand your question, and I think there's a couple parts. And which is take legal action against the company responsible. I think,
Well, company and even just the hackers themselves.
yeah, so there's something called hackback, or basically taking offensive operations, in your own hands. And I think Saren will echo this, and that's illegal, which is, and so maybe I've got your question wrong, but we're talking about a company going back against the individual who's hacking them. Is that your question?
Well, let's take it back for a while. They are going back, but there are many ways. There are legal and illegal ways. One is actually using the courts and then getting a ruling by the U.S. Marshals to seize the servers that are perpetrating this wrong.
Yes.
And then there's other times where, they're basically going in and doing a rat trap and catching these and going into other zombie computers, which is obviously legal because that's a criminal trespass of its own.
Okay, so the first part of your question is a legal question. I think these guys can probably get you better, but
Still answer.
would I advise a client to do? Absolutely. I would advise a client, if they have the ability to do whatever it takes to either bring law enforcement in or do civil action against the company or the individuals who are responsible, absolutely.
I can chime in a little bit on that one. Yeah, if you're talking about legal action, from Microsoft, for example, I mean, they've done sort of botnet takedowns where, they've gotten legal orders to take down the infrastructure used to propagate those botnets. That's certainly something that the private industry can do. It is one area where, I think those companies should be strongly encouraged to work with law enforcement. You've had botnet takedowns that have been attempted by these companies that have only been partial in their success. And partly it's because they haven't tapped into law enforcement. When we have international reach, we can coordinate with law enforcement authorities all over the world and really do an exhaustive job. In terms of that, the hacking back and not going through the courts, but instead just sort of taking offensive action on your own and trying to hack into whatever infrastructure is being used by these criminals. I sort of sympathize, but it's not only that it's illegal, not only under federal law, but potentially under the laws of whatever country the infrastructure is in. But it can also lead to unintended consequences. So you may think you're hacking back into the hacker's system, but it could just be a proxy that they're using to launch an attack from, and that proxy could also be hosting a lot of legitimate activity. I mean, maybe it's a university computer or a hospital computer, and you interrupt their routine operations. So if a company is considering doing that sort of thing, they would be much better off going to law enforcement and saying, hey, we've traced the activity back to this server, can you help us? And then law enforcement can do things like, take an image of that server or work with foreign authorities to do so and follow leads from there. So it's generally not a well-advised strategy.
I think we have another question over here.
Hi, Elliot Sievers. I work with Glenn in the New Jersey Attorney General's office. And one question that we frequently ask ourselves is, can a company take measures that will protect their trade secrets, for example, in the face of a determined actor? And what I'm hearing from Austin and Saren, these actors are frequently very sophisticated nation states. Is there anything a company can do in the face of these persistent, sophisticated threats?
I think the only surefire way to protect any data is not expose it to the internet, not let it be accessed remotely. There are steps you can take to help reduce the likelihood of it being taken, and that's basic cybersecurity 101 rules that unfortunately most companies don't do, which is, two-factor authentication, using a VPN, encryption, monitoring of the privileges inside an organization, careful about what kind of data. But unfortunately, a lot of those things cost money, and companies have to make those types of business decisions. Another big thing is that organizations are looking to decentralize, and they're looking to make the data accessible through every device in your pocket. And the more exposure that data has to these remote devices, there's going to be a way to get in. I mean, I get all kinds of cybersecurity feeds, and I laugh sometimes because, there's organizations that, hack refrigerators, and there's one group that hacked the Samsung smart fridge, and the Samsung smart fridge has a Google, you can display your Google Calendar on the front, and they found a way to get in and steal and compromise the Google Calendar, and people are like, well, who cares? And my answer is, well, how many people use the same password for their Google account as they do for their banking, for everything else? So you steal those Google credentials, now you've got access. Look at just a couple weeks ago, these kids hacked the CIA director, John Brennan, and I think he's the only one using AOL, but so he was, but right. But what did the guy do? He forwarded from his government account to his AOL account his SF-86, which is like a 75-page document that goes back 10 years in your life and has every personal thing about you, including your family and your neighbors, and it's a massive document. And he forwarded it to his AOL account because he wanted to have it more accessible, and now it's stolen by a bunch of kids and put out on the net. So it's accessibility versus security, and there's a huge, huge business decision that every organization goes through to decide. But the bottom line, if I had to give like one answer, I don't think there's any way to protect that data unless it's fully segregated from the internet.
I would just add, I mean, you can absolutely do things to protect you. I mean, it's like saying, well, I live in a house, and there are certain actors. The CIA can break in. Should I, install a lock on the door because it's pointless? Like somebody out there could break in. Like, I mean, it's the same with hacking. With the most sophisticated hackers in the world out there, yeah, they could penetrate probably any system. But a lot of the hacks and attacks that are occurring are not that sophisticated. They're taking advantage of known vulnerabilities and unpatched systems and phishing emails, and and so those things can be stopped through good cyber hygiene and good awareness training. And is it going to stop everybody? No, but they're going to move on probably to the next target and the less protected targets out there, unless they really are targeting a particular entity for very specific data, and they're just determined to get into that system.
Well, we're out of time for this panel, but I think that was a perfect segue into our next panel, which is going to focus on more about what companies can do to protect themselves. So we'll take a break for 5 minutes.